Hearing in the appeal of Lifestyle Equities CV and another, and Amazon UK Services Limited and another.
Mr. Alexander, I apologise for the late start. There appear to have been some technical issues.
Well understood. My Lords, in this matter, I appear with Mr. Kay for the appellants and Mr. Edinburgh and Mr. St Quintin for the respondents. There are, as you know, two issues on this appeal. First is the approach to use of a trademark in the United Kingdom, and that point focuses on the approach to so-called targeting. The second is what one might loosely describe as the Blomqvist point, how that line of case law is to be treated by this court, and in particular whether the approach to sales should be taken as being different or involving a fundamentally different approach to that relating to other potential uses of a trademark. Subject to my Lords, I would propose to proceed as follows. After some brief initial observations, I'll give you a road map which will essentially involve submissions in four heads. First, to consider the law, on which you've had quite extensive written case. I'll just make a few points to highlight some points from that. Second, the approach to application of that law. Maybe said, well, that's all part of the same thing, but it's quite important in the context of law that is potentially applicable to a very wide range of trading situations, that one considers not only what the text of the law is, but how that may apply in a range of situations. Third, how the courts below addressed the facts of the present case, and why, in our submission, the approach taken by Mr. Justice Michael Green is to be preferred to that taken by the Court of Appeal in relation to the evaluation. And under that heading, we'll pick up the points on why the Court of Appeal's criticisms of the first instance judgment were, in our submission, not justified, and develop in somewhat greater detail why the judge's general approach is preferable as a matter of law and policy. It is a somewhat unusual case. Indeed, in some respects, all of the cases that have come before the courts on this issue have their own particular quirks, and I'll show you some of those to assist you in developing the principles. And finally, I'll come to the Blomqvist point and what your lordships should take from the case law on that issue.
Yes, I think the court at some stage would find it helpful to be taken through the consumer's experience of going to Amazon.com and what each stage would be.
Yes.
So if you could find some way of explaining that to the court, I think that would be quite useful.
Yes, I will.
There's an oddity that in the Court of Appeal judgment, the Court of Appeal starts far down the line.
Well, that's an oddity that we have drawn some attention to. Yes. It's perhaps most convenient to address my Lords on that in the section on why, in our submission, the judge's approach was right. Yes. Because what the judge does is he takes all of the various factors relating to the presentation of the website and the features about it, and analyses them in context. And if I can do it in that head, it's easier rather than doing it as a separate chunk right away.
I'm not wishing to take you out of order. I'm just wishing to indicate that the court would welcome that process at some stage in your submission.
Well, we'll certainly do that, and we'll do that also by reference to the findings made by the judge in relation to the consumer's appreciation of the relevant website in issue.
Do we have all the relevant pages that are referred
Well, my Lord, that is, of course, a good question. What you do have in what is tab 48 in the written, I think all operating electronically, so it'll start at 1244 in the PDF or electronic bundle, is the pages upon which points focused. There are other pages in earlier tabs that I don't think anything separate turns on, and so I think on this point you probably have all you need. The reason I hesitate in saying that, my Lord, is because the judge obviously made an evaluation on the basis of the materials before him. There were samples, transactions, and so forth, and so what you will not have is a record of absolutely everything that every consumer might possibly do on a website of this kind, nor would that in fact really be possible in a realistic case. So, subject to one point, namely that some of the print is rather fine, albeit possibly enlargeable on your lordship's screens, I think you've got the key points upon which both the trial judge made observations and on which the Court of Appeal then made observations. And just to pick up my Lord Hodges' point, of course, the Court of Appeal started, in some senses, at the end of that bundle, or the end of that section, in what is described as the review your order page, and we can come on to the materiality of that.
1244 is not the same as that exhibited to the respondent's case at page 144, which has an additional box.
That tab isn't the same, but this is the material from the, I think it's the core material from the trial.
This has the box, we ship internationally.
Yes.
Does that come up when you first come
Yes, it does. Just so that my lords have it in mind, since you're clearly interested in it now, what happens with these sites is that, or this site in particular, is that it's got a so-called picker box. I think you may have picked that up, where there's, in some senses, a default delivery destination, but that is only a default destination. It's potentially the destination could be Tuvalu or wherever, because it is true to say that on the issues, at least before this court, on the matter that your lordships have to decide, there isn't a restriction on the countries to which potentially goods may be delivered. But the way that it works, and one always has to be careful in these issues about who is providing information to whom and what is in response, but the Amazon.com website responds to where it thinks the relevant person is when they're logging into it. So you might say, well, the person is giving them the information, and then the website is responding by saying, okay, well, if you're there, then we can deliver to you there.
Well, I'm not sure. I understand that the case put against you, that doesn't make a difference.
Oh no, I understand. The case put against me is that doesn't make a difference. I was only answering my lord's question, or both my lord's question, as to the nature of the web pages, and perhaps we can come back to that. We'll
let you develop your submission in the order you wish.
I'll be making submissions in relation to that in due course. So, as my lords will have appreciated, our core submission, before we get into the detail, is that the approach taken by the judge, both as a matter of the law and as a matter of the application of the law to the unusual facts of this case, was right. As a matter of principle, it is preferable to adopt an approach of that kind, particularly given the state of internet commerce, the diversity of situations that trademark law has to deal with, and in particular what should be done by the courts in this context, given the nature of the law and its purposes, is to undertake an appropriately nuanced and multifactorial evaluation of all of the circumstances. And there are circumstances which will be, in a sense, positive circumstances, pointing to the fact that someone is willing to engage in trade in a given destination, and there will be negative circumstances indicating that, in fact, that's not really their purpose, and their purpose is, for example, to direct people to other websites for trade in a given country. And what the courts, in our respectful submission, should do is to take into account all of those circumstances as reflected by the full picture of the evidence, and make an evaluation on the basis of that. And that it doesn't really make sense just to take isolated pages in an individual consumer journey, in particular ones that may be at the end of the journey, and focus primarily on those in deciding whether or not the website in question has undertaken targeting in the United Kingdom. So the mere fact that the trader makes it possible to send goods to the UK or the EU, states on its website that it's prepared to do so, and even does now and again do that, is not in our submission without more enough for there to be targeting and therefore use of the mark in the UK as a matter of trademark law, either under the directive or under the regulation or under the domestic law. Our second core point, before I get to the detail of the law, is that Mr. Justice Michael Green undertook a careful and comprehensive and, in our respectful submission, realistic analysis of all of the circumstances in which the website in question and the goods upon them would be encountered, including relevant aspects of commercial context. He looked, and we'll look at this in greater detail, at what Amazon had done and the consequences of it, and what they had not done, including how that would appear to an average consumer, and concluded, and he reached a clear conclusion, that the goods were not targeted at the UK. And the position may be contrasted, because we're dealing here with the Amazon.com website on which the argument focuses, with the position with respect to Amazon's specifically UK-focused website, which is amazon.co.uk, which we accepted was targeted at the UK in the relevant respects for trademark law. So in our submission, what the judge did was correctly applied the principles as they've developed to what was an unusual factual situation, and he deployed a well-established test, looking at all of the circumstances which were under European law for the national court to determine whether or not the relevant instances were ones that could properly be described as use of the mark in the United Kingdom. Now, we don't use the word multifactorial as a kind of appellate noli me tangere kind of mantra, where we say, well, you know, he did the evaluation, there it is, the court shouldn't interfere. We've made points in relation to that, but our submission is actually more fundamental than that, which is that in circumstances where there is a range of factors, some pointing in one direction and some pointing in other directions, it is appropriate to look at the full picture. And what one shouldn't then be doing if one is reviewing a decision on appeal is say, well, I'm going to now say that this particular factor is one that should necessarily be given dominant weight and other factors be given much lower weight, when an evaluation has been made that's a perfectly sensible one. Of course, if one does a very narrow evaluation, it may be impossible to see the case in any other way. One can see, in a sense, an instance of that in the reasoning of Lord Justice Arnold in the Court of Appeal. Once one's got to right to the end of the stage, when one's reviewing one's order and one's asking oneself a question, is this website going to send me goods here? Then the answer to that question may be, well, yes, of course, you're reviewing your order. You may have told them to send it to you here because you're reviewing the order that you've actually placed for them to send you the goods here. Focusing on that right at the end and sort of isolating that point is something that actually doesn't do justice to the full picture of a targeting analysis, and in our respectful submission has the consequence of inappropriately extending jurisdiction over acts that should not properly be regarded as uses of a trademark in the UK. That potentially affects international commerce. In our respectful submission, it does so if one takes this very narrow approach in a disproportionate way, and it imposes costs but no real benefits. Now those points are, if anything, highlighted by some of the arguments made by Lifestyle in the appeal, and they really take the position that, you know, so long as you indicate a willingness to sell or consummate a sale, that's it. And there are no further questions to be asked. That's always of dominant weight. In some circumstances, we accept that may be of greater significance. In other circumstances, it may not be. So before I get to the core points of law, the first segment of the argument. Can I just make a few other preliminary points on some of the general observations made in Lifestyle's written case, with which we respectfully take issue. First, they say that our argument involves saying that trademark law should not apply to Amazon as it applies to others, on the basis that were it to do so, that would reduce Amazon's profitability. With great respect to my learned friend, that is quite wrong. Amazon accepts liability where it's appropriate to do so, and seeks to, as it did here, address concerns in a responsible and proportionate way. And my lords will have seen in the judgment of the trial judge the way in which that was addressed when an issue was raised. Amazon accepted at the trial that some of its past activities with the US Beverly Hills Polo Club goods had been targeted at UK consumers through the UK-focused .co.uk website, albeit to a trivial extent and with trivial effect, and it took steps to address those. When Lifestyle raised this issue originally, it put restrictions in place, first in relation to the global store on Amazon.co.uk in 2018, and then further in relation to Amazon.com, which, as the judge held, removed any possibility of infringements occurring for the future. And those were in paragraph 73 to 74 of the judge's judgment. So Amazon is not trying to be free from trademark constraint, if and to the extent that it does, we say, genuinely target the UK with infringing goods or advertisements for them, then it accepts to, subject to other relevant requirements of the law being fulfilled, it will be liable just like any other trader. The concern here, and the reason that an appeal is pursued, is one perhaps shared by other traders, that they shouldn't be held liable when they do not target the UK or the EU with their websites or their goods. And so this case is really about the extent to which the law of targeting, which we use as a shorthand and for use, should be kept within bounds, what the bounds should be, bearing in mind the underlying principle of the territoriality of trademark rights. It's not about the wider question of whether trademark law should or should not apply to online activities more generally. Second, this case...
So am I right in thinking that your submission is that it's just the Amazon.co.uk website that would need to take account of the trademark of Lifestyle Equities? Is that correct?
Our position was that we accepted at trial that in relation to the advertisements and offers for sale, Amazon.co.uk, which is a specific UK website designed with products for the UK market, which has characteristics that make it suitable for the UK market, including the pricing and the delivery and so forth, is one that is directed to the UK, intending to attract UK business. The Amazon.com website, although it is available in the UK, is a US website. It's directed at the US. It is true that it is not restricted to the US, in the sense that that Amazon has made it impossible for anyone either to access it or to purchase goods from it if they have chosen specifically to go there. But that's no different in principle from a situation where someone says, well, look, I'm targeting market X, but I'm not going to say that no one can purchase goods from elsewhere. And so it's really about that boundary between a situation where someone is setting up something that is directed at a particular jurisdiction, and then, in a sense, it is reasonable to say that they should take account of the rights, not necessarily just trademark rights, but other rights that may exist of those in the jurisdiction, and situations where they don't do it, but it's nonetheless possible for people, as it were, to make what in other contexts may be described as passive sales from a foreign website, in circumstances when that's neither intended by the website operator in question, nor happens through that website, save to an extremely limited, indeed, the judge described it as almost de minimis extent. Now, part of the artifice of this case, as my lords will have picked up, is that the actual casus belli here has got really nothing to do with the core issues of trademarks with which this court is concerned. You may have picked that up from the judge's judgment. What Lifestyle in this country wants to do is to stop anyone seeing that goods are available in the US at prices that are different from the prices at which Lifestyle's BHPC goods are available in the UK. And that was made absolutely express. It's recorded in the judgment on a number of occasions. Made absolutely expressed by Mr. Haddad, who's the moving force behind Lifestyle Equities. He's not really concerned even with offers for sale or sales in the UK. That's a sort of sidewind for his overall objective. And that is a point that is relevant to my lords for this reason. We are dealing here with a situation of, in some senses, two rights. They are parallel. It's not a counterfeiting case. This is a case about legitimate use of rights in different territories, because this is a mark that has been divided. In such circumstances, on occasion, as one sees from some of the case law, one gets what might be called boundary problems as a result of an entirely reasonable and lawful division of the marks. But what Mr. Haddad wanted to do was to say, well, it's not a question of really spillover sales or spillover advertising. I just want to stop visibility of any kind. And there is, in our respectful submission, nothing whatever that this court, or indeed any court, could do to address that particular issue. His concern was that some of his licensees might say, oh, well, look, the prices are lower in the US, and that might affect his licensing position. But
well, if the UK consumer wished to investigate what the mark was selling at in the US, the consumer could do so, I imagine, by pretending to place an order somewhere else in the world. So the outcome of the litigation will not be invisibility, whatever happens.
That's exactly my point, if I may respectfully say so, my lord. The overall objective of this litigation is completely unachievable by any form of law, no matter how extreme an approach is taken. That is never achievable. But
it would be a determined consumer investigating what a product was selling at in another jurisdiction to go through the process of pretending to send it to somewhere else.
Oh, indeed, but one can take the most extreme case. Let's suppose that all of the goods were expressly marked in the United States, never to be sold outside the United States.
You could still find out.
And you could still find that fact out, that they were being sold for whatever it is, yes. $16 rather than £20. I don't know what the precise price differential is. But, and the reason, in a sense, that we are all here is that rather unusual set of circumstances which has brought us to this litigation has, as a sort of sidewind, created a risk of statements being made, which then are taken to a very broad application across the whole field of internet commerce, where the issues are not the specific issues of lifestyle, that then have wider consequences. And if I may respectfully say so, it is against that background that it is understandable why your lordships have thought it appropriate to look at this case, because the much broader issues affect not only this particular case and the language in which any test is formulated. It doesn't just affect this case, it affects trade, potentially, if one looks at it in a broad way, the mom and pop store in Arkansas, who doesn't say on their website, oh, actually, no, I'm not prepared to send goods to the United States, and potentially many others. So the issue that my lords have to grapple with is one that arises in a context in which, in some senses, it doesn't matter, given the purposes of the litigation, but in some senses does matter, because it really is an issue that affects international commerce.
Whether or not the litigation was misconceived, the problem is now with us.
Indeed. So the third general point that we make relating to that is that we are not in any way treating this case dismissively, or Lifestyle or Mr. Haddad dismissively. We're drawing attention to matters that Mr. Haddad himself said about his objectives in this litigation, and we tried to address the in a sense limited reasonable complaints in an appropriate and proportionate way. That hasn't satisfied him, and that's why we are here. And one of the reasons why one might say that it is particularly desirable for the English courts to preserve, so far as possible and reasonable, the flexibility and the ability to take into account all circumstances is exactly because one needs to deal with a large number of different situations. Many of them will involve, or some of them will involve individual trademarks with individual companies. My lords will recall the Merck case, and we'll come on to look at that in slightly greater detail. Others will involve very unusual situations like the Argos case, where essentially a undertaking in the United States discovered a way of making a little bit of money on the side by taking advantage, I mean, my lords, I think, are familiar with what I'm saying here, by taking advantage of the errors of English consumers in putting in argos.com into their web browser and then being able to sell advertising to them. I mean, advertising directed at the UK as a result of those errors being made and not picked up quite quickly enough. Those are two, in some senses, unusual situations. Merck was one where actually the main position between the parties was regulated by a very detailed contract, and that was the main focus of the debate. But the trademark issues also played some role. Similarly, here you've got a situation where you've got divided trademarks. The situations that arise in relation to a commercial undertaking which has a single product with a single mark, where it may be relatively easy to search for whether or not a given rival mark may exist in a different territory, may not be the same as situations where you've got an online marketplace, where the practicalities of someone overseas, whether they be in the United States or indeed even somewhere else in the EU now, undertaking a search in relation to every possible mark that may apply in a market, are much more limited, particularly in the context of, as my lords know from other contexts, a situation where trademark registers are absolutely stuffed with registered trademarks in many countries of the world. There may not be a practicality there. So the advantage of having a flexible test is that the court preserves a kind of ability to control circumstances in which it is reasonable to exercise jurisdiction, or perhaps I can put it in a slightly different way, to treat the jurisdiction as being invoked, and to say, okay, well, we're going to make this factor the sine qua non, or the almost always sine qua non, rather than having a broader view is actually an undesirable approach. So that's our preliminary direction. And with that, can I get straight into some of the case law and the statutory provisions? Now, I don't want to labour this point because my lords have got the material very well in our written, in fact, both sides' written cases. But could I just make a few observations in relation to the law and how it has developed, and what your lordships sitting in this court should take out of the principles as they've developed, sometimes not in trademark context, from the European Court of Justice. But let me start right at the beginning of this, or the foundation of this argument. The starting point is, as everyone recognises and is common ground, that trademark rights are territorial. Now, that point is reflected very well in Lord Justice Arnold's judgment at paragraph 44, where he gives a number of case references to that proposition. And that is a proposition that applies not just in relation to trademarks, but in relation to intellectual property rights specifically. But one might say that trademarks are among the most strongly territorial, or when I say registered trademarks, are among the most strongly territorial of rights. They require registration in a particular territory, they require establishment of use in that territory, and infringement is only established when there is use in that territory. Now, it is true that Article 9 of the Trademarks Regulation doesn't expressly use the term that the marks must be used in the EU, but everyone takes that for granted, and that's really why the targeting jurisprudence has been developed. Just for my Lord's note and record, there is a provision specifically in the UK statute, namely Section 9 of the Trademarks Act 1994, and we can hand that up to my lords if you want it. It's actually not referred to, I think, in any of the cases, because it's like the sort of Grundnorm of this whole area. But what that says is that a proprietor of a registered trademark has exclusive rights in the trademark which are infringed by the use of the trademark in the United Kingdom without his consent. And then the conditions for infringement are developed in Section 10. So there's no doubt that what one is looking for when one is looking for trademark liability, whether under the regulation or under a United Kingdom statute law, is use of the mark in the United Kingdom or in Europe under the regulation. And so one might say, if one takes that as one's starting point, the sort of basic proposition, that whether the law should say that there is use in the United Kingdom, where goods are ordered from a foreign website, bought pursuant to a contract made under foreign law, where title passes to the goods in the foreign country, and there isn't anything specifically tying the website of the foreign country in any way to the UK, that the starting point might be considerable caution before saying that there is nonetheless use of the trademark in the UK, even in relation to sale in the UK, let alone any offer for sale which may take place or any advertisements. The second point where there is common ground, and it links with the first one, is that there is nothing in the text of the Trademarks Act or regulation that expressly addresses the question of international use. Now, that may be so obvious as to go without saying, and your lordships may say, well, why on earth is he making such a sort of self-evident point? And the reason is this. In circumstances where the legislature has said, we want extraterritoriality to a given extent, and it is then for the courts to develop principles of extraterritoriality, or to work out how far an extraterritorial principle should go, it might be said that there is a greater warrant for the courts to say, okay, well, we can be kind of relaxed about this. I mean, I use that in a very general sense. In this sense, that the legislature has already contemplated extraterritoriality. That's the purpose of the legislation in question. And a lesser degree of circumspection and caution is required. And the reason that matters in a case of this kind is because my lords will, of course, be familiar with the case law of Pammer, which we will come on to. Now, Pammer was a case, as there are quite a few in this general area, concerned with the Brussels regime. And one of the things that is axiomatic about the Brussels regime is that it is in part about exorbitant jurisdiction is not the right term, but it is about extraterritorial jurisdiction. There is a special regime for conferring jurisdiction, particularly in relation to consumer contracts, where the legislature has specifically said, we want there to be extraterritoriality. We want consumers to have a choice of states in which they can sue. And we want that because we want to ensure specifically consumer protection for because consumers are assumed to be the weaker party. I paraphrase slightly, but that's the purpose. In circumstances where one has a territorial regime which doesn't provide for that, what the courts are doing is, in a sense, grafting on to a non-territorial regime a court-created extraterritorial impact. And our submission is that caution needs to be exercised in doing so. And that is a reason, it's another reason, why it actually makes a lot of sense to have a nuanced test that has a general characteristics but is applicable in different ways in different cases, so that the courts can actually say, well, here we don't want to really go too far. Now, my lords may say, well, the price of that is that there is then a degree of uncertainty is perhaps not the right term, but there is not complete clarity at the edge of the law in that context, if one adopts that approach. But that is a price worth paying, and it is a price that is paid time and again in trademark law and intellectual property law generally. The concept of confusing similarity, the concept of use such as to affect the distinctive character of the trademark and so on. All of these are general concepts which are specifically provided for by trademark law. None of them have sharp boundaries, and each of them require a degree of careful and comprehensive reflection as to whether it is appropriate in that case. So can I then turn to Pammer and just make a few additional points on that? It's in your bundles at page 1015.
So you say quite a lot of these concepts are fuzzy-edged, so to speak. One doesn't need to be too concerned that one might end up with accepting a fuzzy-edged concept.
That is one way of putting it. The problem with the term fuzzy-edged is that it sounds, in the context of any courtroom, and in particular this courtroom, if I may say so, a term of abuse.
Well, broad-textured, would that be less abusive?
What a lovely phrase. Yes, indeed. That's perhaps a better way of putting it. My point is perhaps is a slightly more sophisticated one. Well, no, that presumes. If one is thinking about a test in law which has to be applied to a very wide range of different circumstances, where both instinct and kind of commercial circumspection suggest that its application should be quite nuanced to those circumstances. There is a case for saying this should be a nuanced evaluation. Perhaps if I can draw an analogy with the law of patents, the concept of obviousness. Now, one might describe that concept as fuzzy-edged. But a better description, not quite as good as my lord's, but would be heavily context-dependent. And there is nothing wrong in our submission with such tests in intellectual property law. There is not a vast body of case law with judges fretting about the uncertainties of the law, any more than there is a vast body of case law, or indeed academic commentary, with people fretting about the concept of substantial similarity in the context of copyright, or even other concepts such as use with or without due cause, or indeed even concepts such as whether or not there is genuine use of a trademark, where, again, that's a concept that it's not a sort of black and white concept for the purposes of retaining validity of a trademark. It's not the case that if you sold one article, that's it, you're in. Yeah? There has to be some evaluation of how that is to be judged by reference to standards reasonably to be expected in commerce in the relevant trade in question. And my lords have just had to consider an issue of bad faith. You might say, well, bad faith, that's in some senses a fuzzy-edged concept in particular contexts. And in some areas, one can say, well, okay, that's clearly going to be right, and others, that's clearly going to fall on the wrong side of the line. And there are others where actually reasonable people may differ, but there is a sense in a particular decision. So to that extent, I entirely accept what both my lords are saying, and in our respectful submission, it is not only sensible to proceed in this way, it does justice to the fact that trademark rights are not just a sort of legal construct for the books. They have a life in commerce. They're there to be sort of servants of the people rather than, or servants of commerce, rather than to be masters of a rather textual or monolithic analysis. And in all respectful submission, none of that is inconsistent with any of the fundamental principles of trademark law. Indeed, it's not even inconsistent with any of the fundamental principles that apply in the context of other areas where one's looking at jurisdiction. So, for example, in the context of the Article 15 of the Brussels regime, where you have a question of whether a contract or a consumer contract is directed to a given country. Does that actually give an absolutely clear mandate as to when it is and when it isn't? No, it doesn't. But one might say it's not just me saying this, because our core submission is that this approach that I'm recommending to my lords has been said not only by the European Court of Justice, but also by the Court of Appeal on a number of occasions for very good reasons, and has actually been taken by those tribunals for very good reasons, and it hasn't actually caused a significant problem so far to do that. So can I just very briefly make some points on PAMA? And I think I've really highlighted already the main points, and your lordships will, I think, have that in mind. Article 15, Brussels regulation case, we can see that from the head note. Just so my lords, you probably have this etched, but Article 15, 1C, of course, requires that in the case of a consumer contract, there may be jurisdiction where the contract is being concluded with the person who pursues commercial or professional activities in the member state of the consumer's domicile by any means, or by any means direct such activities to that member state or to several states, including that member state, and the contract falls within the scope of such activities. So here is an instance of the kind of law that I mentioned earlier, where the basic scheme of the convention is sue where the defendant is. But then it allocates jurisdiction, at least with the EU, within the EU, on the basis of this additional scheme for jurisdiction in a number of different ways, of which this is one. And so where you have that kind of scheme, you might say, well, all right. And the scheme is, as the court noted in that case, one which is in part for protection of the weaker party. Then, in those circumstances, one can adopt perhaps a somewhat more expansive approach. And my lords see that in paragraphs 53 and 55 on down to 57. That's on pages 1025 to 1026 of my lord's bundle. And just to summarize that, rather than inviting you to read all of that, the points there made are, it's a derogation from the general rule and from certain other special rules relating to consumer contracts, that the regulation doesn't define the concept of activity directed to a member state of the consumer's domicile. That's the point made in paragraph 55. And then in 56 and 57, the court says one has to have regard to the interpretation and the changes, and it's clear from the recital, the same place, that the legislation fulfills the same function of protecting the weaker party, as does point 3 of the first paragraph of Article 13 of the Convention. And so, in our respectful submission, when one is looking at concepts that are concerned with direction to, targeting of, and one is seeking inspiration from case law dealing with other areas, including jurisdiction. And of course, jurisdiction is not something that allocates liability. It just says you can sue here rather than you're going to be liable here. One has to be a little bit cautious before taking over the considerations which apply in that kind of context to the context of trademark rights. Now, we don't obviously disagree that the list of various factors that might be relevant is maybe an overlapping list of those that are relevant under a Brussels scheme. But we do say that in the Brussels scheme, what is contemplated in paragraph 80 and reflected in the earlier parts, paragraph 80 is 1029, is that the Court of Justice is there saying that among the evidence establishing whether an activity is directed to the member state of the consumer's domicile are all clear expressions of the intention to solicit the custom of that state's customers. And then in 81, clear expressions of such intention on the part of the trader include mentions offering its services or its goods in one or more member states designated by name. Same is true of the disbursement of expenditure on an internet referencing service to the operator of a search engine or to facilitate access. to the trader's site by consumers domiciled in various member states, which likewise demonstrates the existence of such an intention.
Is there perhaps a difference between a case where one's choosing one of two jurisdictions and a case where it may be said it's possible to direct one's activity at several jurisdictions at the same time?
First, my lord, yes, you're right. There is a difference, and it may well be possible to do that. In our submission, there does need to be a degree of specificity of direction of activity. So, obviously, it doesn't exclude a situation where someone, let's take, for example, the Benelux countries. Yes, obviously, there may be direction to each of those jurisdictions if one treats them as individual territorial jurisdictions. But it doesn't follow from that, in our respectful submission, that if someone simply says, well, you know, I'm not restricting myself to any jurisdiction to which I'm prepared to sell, and you can buy from me if you want to, and you can buy from me if you want to in Tuvalu, if you're in Tuvalu, just as much as if you're in London, that involves, even though my website is directed to the United States in this case, that is a direction to those other territories. And this is why, in our respectful submission, one needs to take a more nuanced approach on this, because otherwise you get to what we say is a completely absurd situation, where anytime anyone says, okay, well, you can buy goods from us anywhere, then you're targeting the whole world. Every trademark appearing on a website is used in every country of the world automatically, which is, in our respectful submission, not something that's ever been suggested by any of the case law, and would be an extraordinary situation, because then you'd say, well, actually, there's jurisdiction, assuming the same approach were taken elsewhere, literally everywhere for everything.
But equally, you could have more than one target or direction, can't you?
Yes. Yes, I'm not ruling out in any way the possibility of having more. I mean, that's one of the factors that one needs to take into account. But the mere fact that someone can purchase from other countries doesn't mean that there is more than one target. What one needs to look at is whether there is a target, and or more than one target, and whether or not, or whether essentially you're dealing with a situation of incidental and passive sales from other countries, which is what we say is the situation here. Does that answer my Lord's question?
Well, subject to Blomquist, which you're going to get back to, no doubt, in due course.
Yes.
But so far as advertising is concerned, you say one has to take this more textured, nuanced approach, rather than simply asking oneself, is it possible to buy from that particular website?
Absolutely. Similarly, insofar as there's a difference between advertising and offering for sale, equally there, that would apply. And I'll come back to Blomquist. And our core submission on Blomquist is that once one's got to that point in relation to adverts and offers for sale, subject to the Blomquist point, there shouldn't be a special rule for any of the individual items of commerce, or aspects of commerce, that each of them are subject, and I'll show my lords the authorities in relation to that, on all of those aspects. But I think my lord has the point, and I don't want to labour this unduly, but what one is concerned with is a decision of the Court of Justice mentioning a number of points that are particularly relevant in a given context. Indeed, some of them are particularly relevant in a very specific context of the provision of services, in that case, travel, or rather reservation services, which are the reason why some of those lists were developed. And so, but the underlying point is that the approach of the court here is to take a nuanced and comprehensive view. It is not saying, okay, well, you must, in every circumstance, take a particular aspect as the dominant aspect. There are some things that it says may not be regarded as so important. There are some things that it may be regarded as more important, but it's not a blanket view. And the point that is made in several places is that these are matters for the national court to decide. And one might ask, well, why is that a good plan? Why does the Court of Justice not say, no, we're going to set the plan. We're going to tell you in detail how you should prioritize different kinds of evidence. One might say one of the reasons for that, although I think it's fair to say it's not expressly stated, is that one can assume that the Court of Justice recognizes the points that I've been submitting to my Lord, namely that you don't want to be prescriptive and you want to give the right to national courts to make these determinations for themselves, because they are well equipped to do so, having regard to their abilities to take evidence, to look at the whole picture of evidence, which is referred to in some of the authorities. And so, against that background, we have essentially 3 points on PAMPA. We don't disagree that some of the facts and circumstances set out in those paragraphs, which are really 81 to 93, may be relevant in given cases. Everyone accepts that the mere fact that it's possible to contract with the undertaking in the examples given doesn't mean that there is automatically jurisdiction. And you see that in paragraph 91. Second, none of that suggests that the mere fact that it's possible to engage in commercial relations is of itself even sufficient to constitute directing, let alone targeting, which I've made my submissions as to whether one should be more careful on that. That may not necessarily suffice. Thirdly, what underlies the thinking is a concept of solicitation, which we submit involves some active purpose, positive acts directed at obtaining business from customers. Now, the concept of solicitation is, of course, well known in a number of areas of law, and I'm not saying that this brings in those areas of law as a matter of national law. The point is more that the language that is used in this case law is suggestive of something that is required, that is positively directed and specifically directed to the member state in question. So that brings us to L'Oreal and eBay, which you find a little earlier on at 893 in the electronic bundle. Now, L'Oreal is sometimes regarded almost, I guess, faute de mieux, as the lead authority on targeting for the purposes of European trademark law. But the CJEU was not really looking at that issue specifically, or to being invited to articulate what exactly did constitute targeting. The question in that case, which prompted the discussion, was a somewhat narrower one, namely whether it was necessary for a trademark proprietor to show that the goods had been put on the market in the EEA, or whether it was sufficient for an offer for sale of those goods to be targeted at the EEA. And you see that in various places. I don't think I need to go to that. So L'Oreal, supported by some of the member states in the Commission argued that it was enough to show the advertisement was targeted at the territory. eBay said no, and the Court of Justice essentially said yes, it is enough to show that the advertisement is targeted at the territories. So the passages that deal with targeting are actually quite short in the judgment of the court, and that's at the bundle at page 950 to 953. It's paragraphs 58 to 67. And the first paragraphs deal with the core point, and then the latter paragraphs deal with the concept of targeting. But again, they don't set out a full plan for the court, for a national court, to determine what it does and does not constitute targeting. The court refers to PAMA in paragraph 64 on page 952 and starts with a negative point, namely that the mere fact that a website is accessible from the territory covered by the trademark is not sufficient basis for concluding the offers for sale displayed there are targeted at consumers in that territory. My lords may note that the PAMA decision came down between the Advocate General and the Court of Justice in L'Oreal and eBay, which is why it's referred to in these terms, and the Advocate General didn't deal with that. But the Court of Justice goes on to say the fact that an online marketplace is accessible from the territory were sufficient. Websites and advertisements, which although obviously targeted solely at consumers in third states, are nevertheless technically accessible from EU territory, would be wrongly subject to EU law. So the courts, both in the context of jurisdiction and in the context of trademarks, are alive to this question and the concerns about making the relevant principles so expansive that they either bring in the jurisdiction of the courts of other states, or potentially make, in the case of trademark law, it's not just a question of you can sue in another EU country. For trademark law, what would be said in terms of expansion of jurisdiction is you can sue someone in another country in respect of acts done in the United Kingdom, say someone in the United States or Japan or China or wherever, because these are issues of liability, not just of jurisdiction. And then in paragraph 65, therefore falls to the national courts to assess on a case-by-case basis whether there are any relevant factors on the basis of which it may be concluded that an offer for sale displayed in an online marketplace is targeted at consumers, and the offer for sale is accompanied by details of the geographic areas to which a seller is willing to dispatch. That type of detail is of particular importance in the said assessment. And then they go on, in the case before the referring court, the website with the address www.ebay.co.uk appears, in the absence of any evidence to the contrary, to be targeted at consumers in the territory covered by the national and community trademarks relied on. Offers of sale on that website, which form the subject matter of the main proceedings, therefore fall within the scope of the EU rules on intellectual property. And one might say, well, that's not a particularly surprising result. This was a local UK eBay website, in that respect analogous to amazon.co.uk, and the court made its observations accordingly. One might say, in a sense, conversely, subject to the point that .com sites are sometimes thought of as being international, but leave that point aside. One's got a .com site, which by many are regarded as US sites. The converse would be the starting point of the debate. And so the dispositif, which is reflected in paragraph 67 of the judgment, is that it's the task of the final sentence, it's the task of the national courts to assess on a case-by-case basis whether relevant factors exist on the basis of which it may be concluded an offer for sale or advertisement is targeted at consumers in that territory. So we respectfully submit, again, strong support for the broad approach. But maybe make a few other observations on L'Oréal. First, that the court did not expressly say, and we would submit neither impliedly, regard the PAMA approach as applicable without qualification. It referred to it by analogy. The list of factors that were listed in paragraph 93 and the other paragraphs of PAMA are not the same list of factors as listed in L'Oréal, because they may be different lists that appear more pertinent for a given case. Second, and this is in some sense to repeat a point that I made previously, there's nothing in L'Oréal which suggests the court should apply a less stringent or more territorially expansive approach to whether there was targeting in the context of trademark law, whereas I've wearied you by saying there's no express statutory extraterritorial provision, to the approach recognized in the context of the Brussels regime. And third, of course, you've got the point that the court made clear that the question of whether there was targeting was a matter for national courts on a case-by-case basis. And we respectfully submit that is a sensible approach to the law. So can I then come on to the English cases, or the key English cases that have looked at this? The first of those recent cases is Merck, and perhaps just to speed up analysis, because we respectfully commend what the judge did by way of summary, and he has actually extracted the relevant passages from Merck. It'll speed up my Lord's reading as well if I can take that from the judge's analysis of the United Kingdom cases. And you will find that in either the key documents bundle or the appeal bundle at 209 to 211. Could I just say, in relation to this, and it'll shorten things a little bit later, that we respectfully commend the judge's summary and analysis of the case law between paragraphs 117 to 127. He looked at the PAMA case and the L'Oréal case and made points on it that are not dissimilar to the ones that I've been making to my Lord, some of them, in a sense, self-evident points, starting in paragraph 117 with the proposition that we were dealing with territorial rights, and these cases have to be looked at against that background. The judge's summary, and we'll come on to the points in a little bit greater detail, not only effectively summarizes the case law, we respectfully submit it thoughtfully summarizes the case law and its effect, what these authorities are trying to get at, and why it is important to do justice to the principles required, that they should be analyzed in the way that the judge did. I don't propose to take you back to the points on PAMA and eBay, but if we can perhaps take the points up where he started on his analysis of Merck, which is at the bottom of 209 of my Lord's bundle, paragraph 120. He summarized the procedural position and highlighted key points from the judgment of my Lord, Lord Kitchen. And the points that he underlined are, in our respectful submission, the key points that we consider, that we submit, that your lordships should particularly bear in mind.
Would it be fair to say this, Mr. Alexander, to pick up a point that you've made, and to apply it in this context? If a site isn't targeted at the consumer, taking into account all relevant factors, it doesn't become targeted simply because a consumer buys from that site.
Right.
And so one must be wary about any sort of backwards analysis of the assessment of whether or not the site is targeted.
That is exactly my submission, my lord, and it is perhaps the underlying reason why, if one looks at the documents, the various page entries, it's actually wrong to start right at the end, after the consumer has ex hypothesi bought the goods, because you're not looking, if you only start at the end, at the whole. What you're almost saying is, well, right, I'm going to do the analysis the other way round. Yeah? Even if the site is otherwise not targeted at the consumer, the fact that the consumer can buy and indeed has bought has made the site targeted at the consumer.
At what stage does one make this assessment? Is it an assessment that can take into account the experience of the consumer as you land on the site and look at the site and take steps to focus on particular items of more or less interest?
Yes.
It can become targeted.
Oh, we have no difficulty with the point that the context of a website may, and indeed in certain circumstances, even individual pages may be of critical importance, but they're not in every case. I think my lord was asking a slightly different question as to whether one can start with something that isn't targeted, and then as the consumer does their journey, they discover, oh my goodness, this is specially for me. Is that what my lord has in mind?
Becoming increasingly focused on me as a potential,
or may become increasingly focused, or decreasingly focused, or retain the same level of focus, whatever that was, at the outset. Our submission in this case is that the website in question did not change in the level of focus on the consumer in the UK. It said, well, you know, we're not stopping you from shopping here. It actually contained a strap line which would indicate that there was a .co.uk site. But the features of the site which the judge took into account, that I'll come on to shortly, were ones that would indicate to a consumer that it was not targeted at the consumer, and that there was nothing too targeted at the consumer. And the final step of the consumer being able to purchase the goods was not a matter of the site targeting the consumer. It was a matter of the consumer coming to the site, not being put off it by the contents of the site, and fulfilling a purchase to that extent. That didn't turn something that wasn't targeted at the consumer into something that was. And that, in essence, is our criticism of the way in which the Court of Appeal, Lord Justice Arnold, approached it. He was looking at it by slicing the issue up without looking at the full picture. Again, does that answer my Lord's question?
Yes, that's very helpful. It may be one can't equate something which is targeted but becomes less targeted with a case where there is no particular focus on any individual consumer, but it becomes increasingly focused on that consumer as one progresses through the journey. Because if it is targeted at you initially, you may say, well, one's attention is attracted, and the fact that it isn't then focused upon you in any greater detail may not affect the position.
Yes, and there may be
you've caught that public's attention.
Oh, indeed, and there may be quite a wide range of situations, which is why it's quite sensible to think about this as needing to look at the entirety of circumstances, and not just what is shown by the pages, but what is reflected in what has actually happened in consumers' use or non-use of that route. Because that is also relevant. If one's dealing with the whole consumer journey, and obviously one can't look into all consumers' eyes, but one can take some objective evidence and say, well, wait a minute, this is an absolutely tiny amount of traffic, a tiny amount of sales from that are sought from the US from the UK. You know, if really there was an attempt to attract consumers' attention, one would really expect a great deal more than that, given what one knows about other matters. So there is evidence that can be brought to bear on those issues. With all the qualifications, this is a matter that needs to be decided from the perspective of the average consumer, which is an artificial construct, etc., etc.
Who is the average consumer when you're looking at a website where most of the activity is conducted with individuals in America? How does one define the average consumer for this purpose?
Well, formally speaking, the starting point would be the average consumer in this country or the EU. As to the characteristics, one would assume that they had the characteristics of ordinary shoppers for goods of this kind. One could envisage situations where, I mean, let's suppose one was dealing with a situation of nuclear reactors. Then the average consumer may be that for goods of the kind in question.
So you must be very careful then about relying upon the fact that most sales are conducted with individuals in the United States. Made individuals in
well, to a point, well, I think the issue is more a comparative one, because there's no reason to suppose that the fundamental characteristics of the consumers in terms of their being purchasers of clothing are going to differ materially between the two jurisdictions.
Yeah.
Nor fundamental questions about consumers such as, which the judge took into account, namely, if you buy on the US website, the shipping costs are so large that in some cases they are, multiples of the price of the product. And the evidence that Mr. Haddad himself gave, which I'll come on to, about what he thought normal consumers' reaction would be. I mean, this is all material that was before the judge that he considered. Can I perhaps come back to that just after I've just dealt with the Merck and Argos points, if that's convenient? And I can take this quite rapidly.
Yes, I'd like to ask you some questions about the average consumer, but I will hold off until you've covered these points.
I'll come back to this and yes, just very, very shortly. So let me just cover these points. So we respectfully commend both the judge and, if I may respectfully say so, Lord Kitchen's analysis in Merck and the points that are highlighted from it. The proposition in paragraph 170 of Merck, cited there at 210 of the appeal bundle, the court must carry out an evaluation of all the relevant circumstances, and those circumstances are set out, and the fact that the relevant circumstances may extend beyond the website itself and include, for example, the nature and size of the trader's business, characteristics of goods or services in issue, and the number of visits to the website by consumers in the UK. Those are all factors that, in our respectful submission, are legitimately to be taken into account. Because if one's asking the question, is X targeted or directed or soliciting business in a given territory, particularly over a long period? And the answer is, well, there is a tiny amount of traffic from the UK over the period in question. That is, in our respectful submission, relevant to determining whether or not there's targeting. All the more so if there are good reasons why the amount of traffic might be particularly small. So if, for example, someone is really keen on I don't know the full range, but a particular top that is available in the United States, they might say, well, I'm prepared to bear this very unusual shipping charge and have it only arrive much later, because I'm specially going to that US site. That's no different from someone flying to New York because they specifically want to go to Macy's to do their Christmas shopping in Macy's because they want the particular goods there. One wouldn't then say, well, Macy's is targeted at consumers in the UK on the footing that someone can go there, notwithstanding the increased costs in question. So coming back to the Argos point, coming back to Argos now, again, my lords will have in mind the very unusual facts of that case, which was I would describe it as the defendant's side gig for being advert promoters. Again, the Court of Appeal, of which my Lord Kitchen was also a member, set out the principles again, and specifically referred to the concept of the average consumer. One would need to look at the acts which are asserted to be use of the trademark to focus on whether those acts are targeted at the United Kingdom. And the scope of inquiry will vary from case to case, as will the factors which are relevant to its determination, and the role of the average consumer on the issue of targeting may differ from case to case. We respectfully agree with that. In some circumstances, it may be that one even has evidence of actual consumers and what they actually do and what they actually think. I think in one of the cases there was such evidence, and that evidence may be of utility in particular cases. In other cases, one needs to take evidence of a different kind and form a view on the basis of all of the material. And Mr. Justice Michael Green says, and we respectfully say that he was right, seems to be saying the test of whether an advertisement is targeted is partially looked at from the perspective of the average consumer. The extent to which it is will depend on the particular facts. Subjective intention may also be relevant, and certainly attention from these authorities, as the average consumer would not necessarily know what the subjective intention of the website operator or advertiser was, nor would they know some of the other relevant factors. It is, in our respectful submission, established that these kinds of factors, which are objective factors, not just factors of subjective intention of the website operator, are relevant, and some of them are factors that are not necessarily going to be known to the average consumer. Some of them are, or some of them are a mix of factors that would be part of the website operator's business operation, and part would be known by the consumer. Among those would be, for example, the fact that shipping costs were so high if you purchased from a particular foreign website. The consumer is not going to notice that. The fact that they've got to pay customs duties and so on. I mean, those are things that are both arranged by the website operator, but they also have a public-facing aspect. And they have, as well as their actual content, they have a sort of informational aspect which say, either more or less explicitly, this is US, this is not for you. So then the judge goes on in 124, and again we say this is a correct summary of the law and the approach. While targeting has become an accepted method by which jurisdiction is established over foreign use of a sign, it should be borne in mind the word targeting does not appear, derived from the CJU's consideration of the meaning of directed in a case not concerned with trademark infringement. This court and the Court of Appeal have introduced the average consumer test as a means by which targeting is to be established. CJU have not, so far as I'm aware, adopted the average consumer test for this purpose. To my mind, targeting imports the notion of taking deliberate aim at something and is quite specific. That such a concept has been adopted suggests the recognition that trademark jurisdiction should not extend beyond its territorial boundaries unless the alleged infringement is so closely connected to the territory, in that the territory has been specifically targeted. Going back to the actual words of the UTMR and Act, I have to decide whether in all the circumstances the defendants have used the sign in the UK and EU. Now, we would respectfully submit that that is not only a summary of what the law is as it is developed over in the European case law and the Court of Appeal case law, but it is what the law should be.
You endorse the deliberate aim?
We do.
Yeah.
We do. And the extent of deliberation of aim is obviously going to be a matter for evidence. What we are not submitting, and is attributed to us, is saying, oh, well, there's got to be some subjective intention. This is not one of these situations where subjective intention is necessary, but there's got to be evidence from which it can be reasonably concluded that the website has taken deliberate aim at that territory or that territory and a number of others in a sufficiently specific way. The judge then went on to look at Stichting BDO and we brought that along in the supplementary bundle. I don't think we need to go to it because, again, the judge's summary is sufficient, I think, for these purposes. What that was about was BDO, the well-known accountancy firm, challenging a largely Filipino bank, and there were advertisements that were circulating in papers that were available in the United Kingdom, and quite a lot of them actually were circulating, including in prominent journals. Notwithstanding that, not targeted at EU customers. So this is not a situation where one can say, well, okay, just because something is circulating in this country, or in that case the EU, there is therefore use in the EU. Even though on the judge's approach there, people would have had to buy the magazines. It's not exactly the same as buying services, of course, because these were advertisements. Buy the magazines in the relevant territory. They would have them notionally on their desks or whatever in city offices, in the case of the banker and Euro money and so forth. Still not regarded as targeting. And the judge analysed it in this way. BDO case, therefore, shows that circulation figures, viewing figures, volume of traffic are all relevant factors in determining whether there's been targeting. Those would obviously not be known by the average consumer. The test cannot be limited to the average consumer, and all the circumstances must be looked at and assessed to see if there's been use of the sign in the relevant territory. And so the judge then summarises the matter. While there's a broad measure of agreement between the parties as to the law on targeting, there was a divergent focus on relevant factors. The claimants concentrated more on the perspective of the average consumer. Is this website targeted at me? Whereas Mr. Meller, who was then acting for my clients, preferred to look at also at the data in relation to volume of traffic from the UK, EU to Amazon in respect to the BHPC listings. He acknowledged, as he was bound to, and as we do here, that it's necessary to look at the average consumer's perception of targeting, but submitted the test is broader, and account has to be taken of all the relevant circumstances, including the data, the subjective intent of Amazon. On the authorities I referred to, I think he is right to adopt that approach, and I propose to do the same when I come to consider the application of the law to the facts of this case. Now, we respectfully submit that that is an approach that has found favour with, in our respectful submission, everyone, I mean, all tribunals that have looked at this until arguably the Court of Appeal's approach. And when I say everyone, the starting point of PAMA is not that you say, okay, well, I'm going to look at it from the perspective of the average consumer. Okay, it's true that the issue was a different one, and the average consumer doesn't feature in jurisdictional case law. But one might think, actually, the average consumer has a role in average consumer law. So it was a consumer, in this case, about consumers to that extent. Similarly, in L'Oreal, factors were taken a range of factors were taken into account, and in the United Kingdom case law, a range of factors, what might be called objective and, we won't say subjective, but questions that indicate the degree of deliberateness of addressing a particular territory were regarded as all of importance, and that is, in our respectful submission, the correct approach.
Yes. Yes, I mean, Merck at 170, which is set out at paragraph 120 of Mr. Justice Green's opinion, seems to be wholly consistent with paragraph 127.
That is my point.
Yes, but which does mean that the average consumer isn't the whole answer. It's a construct by the court, taking the focus away from the subjective intention of the trader. But the average consumer, the construct has attributed to him or her knowledge that a consumer could not possibly have, such as the number of hits on the website and things like that.
Well, one might put it, if I may respectfully say so, your Lordship is right as to result, but I would respectfully suggest that the reasoning to that destination is slightly different. The case law does not say, okay, well, I'm going to notionally attribute to the average consumer knowledge about what other average consumers are doing or have done, namely whether they have or have not bought or sold.
No, what actual consumers
what actual consumers have done.
Yes.
So the starting point of my Lord's question is, of course, absolutely right, because one's dealing with a construct when one's dealing with an average consumer to begin with. It's not as though the average consumer is someone from whom you take the oracle in the sense of a real consumer and say that's the average consumer. The way in which the case law has analysed these issues, and we submit correctly, is to say that one looks at how consumers, who are assumed to be the average consumer because real consumers are not needed for this analysis, would appreciate the whole experience. And that can be evidenced by what has in fact gone on, what one knows objectively has gone on. So an insight into the mind of an average consumer is whether they've bought any goods in significant quantities. I mean, if you want to know what the public, notional or real, think, you might say, well, actually, let's see whether they're voting with their feet or have voted with their feet in a particular way. So that's one way in which what might be called evidence not known to individual or average consumers may come in. But the other way is that if one is looking at the question of targeting, one cannot completely ignore what the website operator is trying to do and has achieved. And that is something that involves looking at, as it were, the outgoing as well as the incoming. And in making the evaluation of targeting, we respectfully submit that the courts have recognized that they have to look at what has gone out from the trade in question and what also has come to the average consumer's eyes or attention. That is the way that one looks at it. And one might say, well, this is sort of construct upon construct, because ultimately one's trying to decide whether or not there's use in the United Kingdom. But if one's going to use the tool of targeting to determine that question, one has to look at both those sides. Is that to answer my Lord's question?
Thank you.
So can I then turn to how the court below dealt with that on the evidence and the reasons why we say the Court of Appeal was wrong to criticise that. I think this is really the third topic. What I've done so far is covered the law, the approach that should be taken to application of it, and I'm now coming on to the way in which the judge did it and why we, again, commend that to you. And so could I invite you to take the judgment again and start, I think probably the best place to pick it up is at 160, where the judge performs the analysis. So what the judge did was take the principles and apply them, and he summarised where what the evidence showed, starting at 164, the bottom of page 223, in relation to traffic on the website. And he had also analysed the fact that UK customers who chose to stay on Amazon.com and to shop from there are making a conscious decision to do so, despite knowing that it would be simpler, quicker, and most likely far cheaper in respect of shipping costs and import duties to shop on Amazon.co.uk. He referred to the fact that items displayed on Amazon.com shown as not eligible for shipment to the UK, which is an indication that Amazon.com is not targeted at the UK. I'm sorry, I think I gave my lords the wrong reference. It's 163 rather than 164. But he made those points 163, and then he reinforced those points 164 by reference to quantitative material relating to the volumes and figures on visitors. Now, it is said on the other side of the case that he didn't adequately consider the contents of the particular pages on the website. That's just not so. In 165, he went in detail through the contents of the relevant pages and analysed what was actually on them in the consumer journey. And can I just go through those briefly, and I can show you some of them in response to your point. And he did so thinking about this, in a sense, both from the perspective of the average consumer and from in some senses, a more objective perspective. But these were points that were made by the claimant, in which he took into account. First of all, that it was said that the .com suffix doesn't indicate a particular country. On the home page, where he described an example, the UK consumer is recognised, and the page is tailored to make it easy for the UK customer to purchase from Amazon.com. There was no question about that it was not made difficult to buy from Amazon.com. And then, and I think this was a point that my lords were asking about right at the outset, in the top left-hand corner of the home page, the UK consumer sees the statement, "Deliver to United Kingdom." A pop-up box automatically appears from there, which says, "We ship internationally. We're showing you items that ship to the United Kingdom." And I think just to pick that up, the journey, what you would see, and it's, if you've got it electronically, it's not that easy to see. On page 1244, you can probably expand it.
This is what the UK consumer sees landing on the website.
Yes. So it would say delivered to the United Kingdom, but the picker box, so that's the point, that the picker box, which you can change if you want to, would default to your country, essentially. So it's not saying specifically, it's not arranged to be specific to the United Kingdom. It is a indication that delivery will take place to the country from which can take place, in principle, to the country where the person is situated, although that can be changed.
Is there a page where the pop-up box is displayed? A page in the bundle?
144.
There is
144 in the key bundle document.
No, I'm in the...
No, it's in the general bundle, 144. Because it's 97.
I think it's 1246. It's a little bit small in the physical volume. Does my lord have that?
I'm just going there. Yes, and I can grow that.
Let's see whether I can grow it as well. So.
Yes.
I think it might actually be.
Well, that's as quoted in the judgment.
Yes, 1246.
Yeah.
Yes, if you go to the home page from the United Kingdom, that's what comes up immediately.
Yes.
You don't have to do anything else. That box will appear without you clicking on deliver to the United Kingdom or anything of that.
Yes, I think that's right. But the point in relation to that is that would be so wherever you were.
Yes, if you did in France,
if you did it in Tuvalu, it would say Tuvalu. If you did it in France, so there's no element of specificity about that. It's. I mean, in one sense, you could say that the user has given the website information about where the user is by making the search, and the website has, in a sense, reflected that back by saying, deliver to you, because we have detected, on the basis of information that it's not that you typed it in and said, okay, I am in the United Kingdom. It's an automatic feature of the system. But it's not because it's specifically directed to the United Kingdom. It's because it just does that wherever you are.
And immediately to the right of the main block where you enter what you're interested in, it says EN, and then there's a globe.
Yes. And you can change I think that's the language click.
That's the language click.
As far as I'm aware, yeah.
And then to the right of that it says, hello, sign in.
Yes.
And if you're not previously signed into Amazon.com, what happens?
I'll have to check that with the team. I'm not sure that's specifically dealt with in the judgment, but I'll find out. And the problem with giving you an answer on the fly is because it may not be exactly the same at all times, and indeed possibly even for all locations or all accounts. I just feel hesitant in answering that question.
And underneath that it says you're on Amazon.com. You can also shop on Amazon UK for millions of products with fast local delivery.
Yes, and then
you're invited to click onto that.
You're invited to click onto that.
Do you know the answer to this question? If you were in the United States, would that box in the top left, deliver to the United States, appear or not?
I am almost certain that it would appear. where I'm slightly hesitant is whether it might appear even more specifically than that, so deliver to a given state, because it may come up deliver to Massachusetts rather than deliver to the United States. I just don't know.
But as far as you're aware, that similar box appears almost wherever you are.
Yes, that's my point.
Yeah.
That's my point. It's not a specific box that's targeted at a given jurisdiction, and nor is it in a sense an active box in this sense that it appears regardless of what the system thinks it has been told by you is your location. And when I say told, again, I mean that in an electronic sense, told, rather than a... So, for example, you can change that box. If you're in the United Kingdom, you say, no, deliver to France, or deliver to wherever. And it will then maintain that as deliver to wherever it is.
But what, I mean, my understanding was that, or maybe I misunderstood, that you were submitting that the Amazon.com was targeted at the US.
Yes.
But there's nothing different, even if you're in the US, than if you're in the UK.
Oh, I see what you mean. In relation to that particular feature, there isn't anything different.
Right.
In relation to a lot of other aspects of the site, it is quite different.
Right.
The whole point being, if you're on the US site, you have goods that are marked in dollars. You see that on the following pages.
And far more goods.
Far more goods. There are goods that are specific for the US market, I mean, which have been selected for the US market. And although they don't, although it's said underneath them ships to the United Kingdom, it is clear from the website that these are, in a sense, the default price is in dollars. And I'll just come on to the findings that the judge made in relation to this aspect, which are important. I'm told that in the US it does identify the state. We'll perhaps check that over the adjournment. So,
if you had an account, it would probably identify your postcode or...
Well, yes. I mean, what I'm not in a position to tell my lord on my feet is exactly how the site reflects back to you the information that you have given the site about yourself, including by way of having an account. But it is, because there may be cookies, and I mean, one just doesn't quite know what the position is in relation to every possible use. But my point is that this is not a case of a specific entry saying we are taking the US site and we're targeting it at you. That's not what is happening in this case.
Yes, if you have certainly in the UK website, if you have an account and go into your account and then order something, I think they will come up automatically with choices of delivery addresses based on what you've done in the past.
Yes.
And also methods of payment, which credit cards you want to use, things like that. If you've got an account, that's already there.
That's my point, my lord.
Yes.
But the reason it's there is not because Amazon has kind of focused on you.
No, you've put it there.
You put it there.
Yeah. Yeah.
And as we know from experience with the internet, the number of things that, as it were, people put there is quite large. Some of them, in a sense, without them knowing that they've put them there, if I may put it like that. But it's nonetheless things that they have put there, and that's the real point.
Just for my information, within the United States, I'm assuming that there is a trademark that covers all states. we're not getting into intra-jurisdiction issues, are
I'm
we?
not in a position to answer that question, but Mr. Edinburgh, I'm sure, well, I don't know whether he will be able to, but this is a question probably to be addressed to two other of Mr. Haddad's brothers, if I may put it like that, who I think are the proprietors, or their companies are the proprietors of marks in the United States. I mean, generally marks in the US are federal rights, so they would cover the whole territories. I don't know whether that's absolutely comprehensive for all of the United States territories, but that would be the ordinary starting point.
Thank you.
So, as it were, perhaps just keeping those pages open in case we need to look at them. And coming back to the points on the judgment in 165. Sometimes banners appear quite prominently saying we ship 45 million products around the world. Click here to shop in your local currency. I've drawn attention to that already. You can shop in various languages. Bottom of the page indicates that clothing is available, and so on. And then there's the strapline that my lord has referred to. And then the argument is recorded on that basis. And the counter materials are then also recorded. And in our respectful submission, while it is obviously right for the judge to have taken account of the points that were made in 165, it was equally right for the judge to have taken account of the points that were summarized in the points made by Amazon in 168 on to 170. And those were, first, that the features in relation to ease of customer experience, in some senses, only come into play once you're already on Amazon.com. And my lords have to remember that from the United Kingdom, although it's available from the United Kingdom, it's not something that comes up first in the searches. It's down the list on the searches. So you have to be thinking, okay, I want to go there to begin with. If you're searching for Amazon.com. If the UK consumer really wants to continue and pay the sometimes absurdly high shipping fees and import duties and to wait much longer, then Amazon will help them to pursue that course and make it as smooth as possible. And of course that's recording the argument that was made by Mr. Miller, but in fact that was supported by the fact, not only the facts on our side of the case, it was supported even by the evidence of Mr. Haddad, as I shall show you. And that is a downstream consequence of the decision of the UK consumer who positively wishes to shop on Amazon.com despite the drawbacks. And it was then submitted, and we endorse that the average consumer is not stupid. They realise when they get there, whether deliberately or mistakenly, that it's the US website, made a point about searching, it's primarily intended for US customers. Even though Amazon makes it easy for them to navigate around the site and to proceed to purchase items that are listed, the average consumer knows that Amazon.com is targeted at the US and not at them. Now one might say, well, that's actually a finding in some senses of fact or mixed fact and evaluation of what the perception of the average consumer would be with respect to that site, having regard to all of these features. Now that is an evaluation of the average consumer's contact with the site that in our respectful submission ought to be given the greatest respect. It's not obviously wrong. It's, in our respectful submission, clearly sensible and correct.
It's part of the submissions, isn't it?
And I understand that's part of the submissions. Let me now develop why that's supported in the evidence. So if you go to the next paragraphs, 170 onwards, 225 to 226. Mr. Mellor also submitted that where there's confusion on targeting UK, its website as a whole. There's confusion as the claimant's case as to whether the website as a whole. That doesn't matter so much as matters have developed. But he does record the data in 170, which is important. In relation to the latter, the data produced by Mr. Campion shows clearly the number of EU consumers who viewed listings the HPC products on Amazon.com was minuscule by comparison with US customers. That is an important finding of fact. The number of EU consumers who went on to buy BHBC products which they could, even smaller, both in absolute terms and in comparison. The figures show that for the 7 years, 2013 to 2019, 168 units of EHBC goods with a total value of $2,600 were shipped to the EU. By comparison, 32,000 units of EHBC goods were delivered to US customers in 2019 alone. We're dealing with a completely different order of magnitude. And then there's this important point about the shipping costs. The average shipping costs of BHBC products as a percentage of the product costs are 2.1% for US deliveries, as compared to 36.4%, a shipping charge of that for shipments to the EU. And Mr. Haddad, who one has to recall has some experience in clothing retail, accepted that no normal consumer would pay a shipping charge of that amount. Now, in our respectable submission, where the website taken as a whole has clear indicia that it is directed to the United States, clear indicia that there is an alternative website that is a UK website, where even though shopping is not made difficult, it is clear from all of the evidence that it is difficult in the sense you'd have to pay sometimes a multiple of the product charge to obtain the products at all. In our respectful submission, what is an average consumer to think? The judge's conclusion that it was plain that Amazon.com and the BHBC listings on it are not targeted at the UK and EU consumer. And in our respectful submission, having taken into account all of those factors, he was right. And he gives reasons for that. My Lord says some of the points are parts of submission and some of the evaluations. In paragraph 171, we submit those are really important findings of fact. Such a consumer, he goes on in 171, such a consumer knows full well that they are viewing or shipping on the Amazon website. Shopping on the Amazon website is primarily directed at US customers. Claimant submitted it's irrelevant that Amazon.com also targets US customers, but in my view it's highly relevant if the average consumer believes that Amazon.com is targeted at US consumers and not them. They will clearly have appreciated all the disadvantages to them of shopping on Amazon.com for delivery in the UK, but decided they wish to do so anyway. Having made that decision to shop on Amazon.com, despite all those disadvantages, it seems to me largely irrelevant that Amazon therefore thereafter makes the process as painless and easy as possible. So what the judge is doing there is taking into account the nature and presentation of the web pages, the characteristics of the average consumer, the contents of the website taken as a whole, the nature of the goods and the reaction of the average consumer to the goods in question on the website, and makes evaluations that are in accordance with what one would say, just stepping back from the matter, is this a site intended for the UK? So, in all respectful submission, that is having regard to all of the pages, a perfectly reasonable conclusion. And the only way in which one can unravel that kind of conclusion is to say, well, I'm not going to look at the whole picture at all. What I'm going to do is to look at isolated pages, in particular the pages at the end of the process, and conclude that because one can take things from individual pages, then that constitutes targeting. And we respectfully submit that's what the Court of Appeal did, and it was not correct to do so. So can I very briefly go through the reasons why we say that the Court of Appeal's errors were themselves not ones that ought to have been regarded as errors, if that would be of assistance to my Lord. But my Lord wanted to ask more about the average consumer.
No, I think it's important. If you're saying that the Court of Appeal was wrong to make its own assessment because you say there is no error, then I think you'll have to go through
Yes, that's what I was going to do.
What the Court of Appeal said were errors and nullify them.
Can I just take that fairly briefly orally, because we've actually set that out in quite some detail in our argument. But if I can just invite my lord to go to the Court of Appeal, a decision which is in either the key bundle or we can take it up at page 164 of the appeal bundle. So there were 6 errors. First, paragraph 68. First, diverted by arguments as to the targeting of the Amazon.com website as a whole, didn't conduct an analysis of the targeting of each of the types of act complained of. Well, in all respectful submission, that's just not right. At trial, it's true that Lifestyle chose to argue that the Amazon.com website as a whole was targeted at the UK and EU. But despite putting it that way, the judge said at 172 of the judgment that it wasn't appropriate to look at that issue, and so he looked at specifically, and I think I've shown your lordship the paragraph, or it's the paragraph just after the one that I've showed your lordship. The issue is whether the relevant sign has been used in the UK and EU, and in that context the use must be by way of an offer for sale or an advertisement. So he was focusing on the listings. And it's very difficult to see that his eye was taken off the ball when he's actually gone through the relevant factors and actually specifically said, I need to focus on those listings. He then referred back to the L'Oreal case and specifically said at 173, when one's trying to determine whether a sign has been used in the territory, it's necessary to look at the particular sign in question. And so he considered them individually. In our respectful submission, this simply wasn't an error made by the judge at all. Secondly, it said under that head of the first error, he didn't undertake a separate analysis in relation to the later stages of that process. But it's not even quite clear what that really means. If it's suggested that the right approach to determining targeting is to salami slice the whole of a set of transactions or the whole of a situation and say, well, that issue taken in isolation, and if it was surrounded by other things, would constitute targeting, we respectfully submit that that would be the wrong approach. And it's true, he didn't take that wrong approach. He took the right approach, which is not to do that. Second point that the Court of Appeal makes is that at paragraph 69, they say that the trial judge erred by accepting Amazon's argument that because Amazon.com was directed at US consumers, the relevant web pages were not targeted. Again, the judge's approach was much more nuanced than that. First of all, he'd identified right at the outset of his judgment, and one sees that in paragraph 5. I haven't gone to that, but I'll just give that to you as a reference, and it's in our written case, that the issue at the heart of the case was whether the BHPC listings on Amazon.com targeted UK consumers in addition to the US consumers. So the proposition here is that the judge, having identified the issue at the heart of the case, then went on to ignore it when he was making his factual evaluation. We respectfully submit that's not a very likely thing that the judge did. And in fact, one can tell that's not right, because the judge's characterization of the issue did take into account the uncontroversial proposition that a website or part of a website can be targeted at more than one territory, something that we do not resile from at all. The judge had that proposition in mind when he was considering the issue of targeting. And we respectfully submit that the judge didn't, as we suggest the Court of Appeal suggested, conclude that since Amazon was directed at US consumers, it necessarily followed that the relevant web page could not be targeted at the UK or EU consumers. That's not what he found. He found that on the evidence as to the reaction of inter alia, the average consumer, in the UK and the EU, it was not targeted at the UK. So that was an evaluation that the judge made on the evidence before him, and an entirely reasonable evaluation. He found, as a matter of evaluative fact, that the average consumer would believe that Amazon.com was targeted at US consumers and not at them, and that was, as I have submitted, a realistic evaluation. The third error was that the Court of Appeal, it said the Court of Appeal said the trial judge introduced a requirement for subjective intention to target. He didn't. And in all respectful submission, that misconstrues the judgment. The judge considered the authorities relating to the relevance or irrelevance of subjective intention, and he actually, in our respectful submission, cited authorities which made it clear that subjective intention may be a relevant factor, but it's not a requirement. And indeed, the judge did not make a finding of no lack of subjective intention. He was looking at the matter as he was entitled to objectively. The judge said, in our respectful submission correctly, that targeting imports the notion of taking deliberate aim at something, but as I've said, taking deliberate aim at something is a matter of objective evaluation. It's not just a question of subjective intention. So we respectfully submit that it is not a fair reading of the judge's analysis to say that he was doing something that he'd said a few paragraphs previously would be an inappropriate thing to do. The next point, at paragraph 71, the Court of Appeal said that the trial judge dismissed the factors relied upon by Lifestyle because they were said to be explicable, as Amazon making the process as painless and easy as possible, and that there was no evidential basis for assuming that such a decision had been made. Again, with respect, that was an unjustified criticism. The relevant paragraph of the trial judgment I've shown, my lords, 171, where the judge found on the facts that the average UK consumer would believe that Amazon.com was targeted at US consumers and not them. And they would have appreciated the disadvantages of shopping on Amazon for delivery in the UK. Now, that was a finding of fact based on material about what the consumer would actually take. And as I've shown, my lords, material that it was reasonable for the consumer actually to take from the experience of shopping on Amazon.com for delivery to the UK. And the trial judge said, well, if once you've decided to do it, then the fact that you can put your credit card in easily or whatever, or it will say, well, I can get it to you by next Thursday week, is actually an irrelevance to the question of whether or not there is targeting. And that's why the painlessness thereafter is not relevant. Court of Appeal's criticism there was that there was no evidence the consumer had already made a decision. But that's not what the judge held, and is in fact not the case. The judge's evaluation of this issue was wholly logical and correct. Consumer can rationally think, it's not intended for me, but go through the transaction knowing that, and indeed being, I might say, grateful to the undertaking for making it not too difficult, but nonetheless saying, well, I realise I'm shopping. I realise I'm on Park Avenue. I know that. I still want to have it as easy as possible to have my Christmas presents wrapped. But I know that it's not targeted at me in the UK. Fifth, the Court of Appeal simply disagreed with the significance of the larger shipping costs and the import duties. Now, this is actually a very surprising disagreement to have with the trial judge's evaluation, since the evidence before the judge, indeed the evidence in a sense, of a retail expert in this area, was that normal consumers, as I've indicated, would find this a turn-off. So to say, oh, well, I'm now going to set at naught or just completely redo an evaluation in circumstances where the evidence before the judge was cogent that he based his evaluation on, in our respectful submission, that is just not right. Indeed, it's particularly surprising because in some of the cases that we referred to, including Walter and BDO to a degree, these sorts of points about volumes of sales were regarded as relevant as to whether or not there was targeting in a relevant jurisdiction. So we respectfully submit that wasn't a proper basis for criticism. And finally, there was a point about the Court of Appeal saying, this is in paragraph 73 of the Court of Appeal's decision, the Court of Appeal said the trial judge treated the evidence of Mr. Haddad as relevant to the question, which it wasn't. Again, he didn't do that. My lords will have seen in the passages just following the ones that I've shown, my lord, recording the points and the evidence of Mr. Haddad and what his objectives were in the litigation. Those didn't have anything to do with the findings in relation to targeting.
But you say that from 175 onwards wasn't part of the judge's reasoning, in effect?
We reached the conclusion in 174.
Yes.
So, in our respectful submission, and please forgive me for doing it briefly and I hope not discourteously, we submit that this was not one of those cases where the trial judge's decision was sort of riddled with clear errors of principle, approach, plainly wrong, I think in the language of some of the case law.
In order for the Court of Appeal to go into this themselves, they have to demonstrate, do they not, that the multifactorial evaluation of the judge was plainly wrong.
That is, with respect to my lord, exactly our submission. Mm-hmm. And we submit that not only was it not plainly wrong, the judge was right to come to the clear conclusion that he did on the evidence before him. And what the judge's approach does, just bringing this point or this matter to a close, is it actually highlights the desirability of the flexible approach which my Lord Kitchen has articulated in Merck and which has been reflected in the case law. It actually means that a court can do justice to all of the circumstances, and that is what the trial judge did, and did so in a commonsensical way. What one does not want to have in this area is what one of my former colleagues used to describe as mechanical jurisprudence, where you take a sort of text and then without thinking really about what the context of it was, the way it applies, take a sort of bit of language and you say, okay, I'm now just going to read this across as though it was a statutory, a very well considered and detailed statutory provision. Trademark law is not a subject for mechanical jurisprudence. It is a subject for reflective, thoughtful, and commercially contextual jurisprudence in our submission. And that is what the judge did.
Mr. Alexander, could you just help me with this? I'm sorry if I've missed it in your submissions. Do we have a review your order page? And do we have the full product details page?
We do, I think. I'm just checking the review your order as to where it is. I think it is
145
in the end of the tab that I just gave you, but I just need to check that. Because it is just possible that the things that are in your bundle are not exactly the same as the Court of Appeals bundle. Oh, it's 1255.
1255.
1255, yes.
Which one is that?
It's when my lord says which.
Well, I beg your pardon. There's a review your order page and a full product details page.
Oh, right.
Which are referred to by the Court of Appeal.
Yes, the review your order page is 1255. And I will just check the full product details. we think it's 1251. Could I possibly come back and give my Lord the reference after the short adjournment to that? Because we just want to be sure that we are all referring to the same thing that the Court of Appeal referred to.
Yes, please, that would be helpful.
But I think 1251 is the correct.
Can I just be clear as to the submission being made about what Amazon.com is targeting? So you're saying it's targeting the US, but you are not precluding that it may be targeting some non-US countries, as I understand it. I think you said, at least in principle, there's no need for any particular targeting to be limited to one jurisdiction.
Yes.
Whether you're saying that in relation to this particular site, it may or may not be the case. I don't know, but if you've got an answer to that, that would be helpful. But then, I think you also said earlier on that the arguments being put by Lifestyle effectively mean that Amazon.com is targeting the whole world. I suspect that you might wish to qualify targeting the whole world by the whole world to which the goods can be delivered. In other words, that would click up as, in terms of where you are in the world, where the goods can be delivered, that left-hand top box. Is that right? That's how you would characterise an argument put against you, that in effect it drives Lifestyle to say that this Amazon.com must be targeted at multi-jurisdictions, perhaps not quite so far as the whole world, but maybe not so far short of that. Is that right?
First, to answer the questions in reverse order,
Yeah.
Yes, that is how we would characterize their argument and the reductio consequences. In relation to what Amazon.com targets, I don't think that, if not the UK, as it were, and if more than the US, I don't think that issue was actually really considered by the court, and I think I'd prefer not to make any submissions on that, because I just don't know what the right answer would be to that question. But does that answer your two questions sufficiently?
Thank you very much.
So, anyway, that wraps up, I think, our submissions on the first aspect of the appeal. Can I then turn to Blomquist?
Just before you do,
Yes.
I've got a sort of factual black hole troubling me. One can imagine a situation where on the .com site, which I suppose broadly reflects some warehouse or group of warehouses in the US from which delivery can be made cheaply if you're in the US, there is a certain product which may or may not also be on sale in the .co.uk site, which presumably reflects what Amazon have sent over in bulk to warehouses in the UK, from which much cheaper and quicker delivery can be made. In relation to these, I mean, bearing in mind we're meant to be concentrating on these particular products displaying these trademarks. So, for example, if it's the right page, 1251, which still has the deliver to the UK thing at the top, seems to be there all the time. I mean, I simply don't know whether Amazon is offering this shirt both on the US, the .com website, and the .co.uk website, so that all the indications are that you might do better to go to the .co.uk one, or whether the reasonably intelligent consumer would actually go to the .com one because what he wanted wasn't on the .co.uk one, and therefore deliberately wanted to go and see what was on the .com one.
Yes.
I just don't, it's a complete black hole both generally in terms of I don't know how Amazon's shop, online shop if you like, differs as between the two websites, and much more particularly how it does or did at the material time differ for these products, which both the Court of Appeal and the judge said were what we should really be looking at.
Yes, your Lordship is of course absolutely right. The record isn't complete on that aspect, either as the general matter of exactly how Amazon or indeed other organisations arrange their affairs, because you could envisage, if you order something from, not these products, I mean the question poses an issue, but you could envisage if you order I don't know, charger or something like that from .co.uk, and it's not in the warehouse in wherever it is. It might get sent over from a warehouse in Germany or even America or wherever. So it's not completely clear, and I can't give you an answer now as to whether what appears on an amazon.co.uk website reflects what is in an Amazon warehouse at a given point in the UK. That's, I think, the first question that you... Or the
yeah, well, I'm slightly assuming that from the findings about it being quicker delivery and much, much cheaper delivery. It must be over here already.
Yes, I'm speaking in complete generality
sure.
of products in general, but that is likely to be the case, but I can't give you specific material in relation to that. In relation to the comparability of goods, whether that shirt is available on .co.uk, I think it is extremely unlikely, on the basis of the findings of fact, that it would be. And if anything, that in some senses reinforces our point, because there may be people who want to go for a particular, I can't remember if this is a radio shirt, anyway, one of these sorts of shirts, who might say, well, I'm going to go to America. Get it. Well, I don't have to go to America, I can go to America from my desk, as it were, to get it.
Well, I mean, there are items that you'd have to go to America to get. If you wanted a cap which said "Make America Great Again," it's probably not for sale in the United Kingdom.
Absolutely. I mean, it may be on some specialist websites. But my point is this: that as a matter of generality, the range of goods that are available on the UK website and the range of goods that are available on the US website are likely to differ. And that is likely to be the case, not just for these products, the products with these brands, but across the board.
Mr. Alexander, could you help me on this point too, if you'd be so kind, before the adjournment? In relation to the page that clearly subject of considerable focus in the judgment of the Court of Appeal, the review your order page, which you've identified for us, whether one takes that at the beginning or the end, and I understand your submission that it must be taken at the end, it is said by the Court of Appeal to be indisputably and accepted to be an offer for sale of the goods at that stage. And it is said, looking at all the relevant aspects of that page, which the judge did not do, it constitutes an offer for sale targeted at a consumer in the UK. I understand your submission that must be very careful looking at this ripped out of the context of the whole, but I understand your submission, please, in relation to that. You accept it as an offer for sale at that stage. But your submission is it is not targeted at anybody in the UK.
No. It is, that is a page that is summarising what the customer has ordered. Because...
Well, there's no order at that stage. There's no sale...
No, my lord is right. There's no sale at that stage.
It's in the process of ordering.
It's summarising what the customer has asked for.
Yeah.
So once a customer has asked for something, to say, well, because the customer has asked for it, and the website has said, has reflected to the customer, this is what you asked for, have I got it right? Which is essentially a review your order, what a review your order page does. It says, this is the shipping address, this is the payment method, do you want to add a gift card, and so on. These are the delivery details. This is the product that you have told me that you want. Before you hit pay, we're helping you with this. To say that is targeted at the consumer because the consumer has ordered it from the website. We respectfully submit that is not realistic. What the website is then doing is saying, okay, well, this is what you told us. I mean, if one looks at the material on this page, a lot of it is material that will have had to be supplied to the website. So the shipping address is being supplied by the consumer, in this case, Holborn Viaduct. It's not something that the website is pushing out, to use the language of some of the cases. I've hesitated in drawing my Lord's attention to that one. It's not pushed to the consumer. This is the consumer having tried to get goods from the United States, and the website's saying, is this what you want? And that's why we respectfully say that it's quite wrong to look at this in isolation, to say, okay, well, if you are just looking at this as though it was something that was a kind of spontaneous order or spontaneous offer that's put out by Amazon, it's not. This is a response to what the consumer has sought. So that's
we're not getting into technical questions about where the offer and acceptance takes place in English law. No,
we aren't. And in fact, if one gets into the technical law, there's common ground that the actual contract was concluded certainly it was one where title passed in the US pursuant to US law. Quite where the contract is concluded on the internet, I think I prefer to do some research before making submissions to you on that.
In contract language, this document is probably Amazon's offer to sell. In the sense that there's no contract up to this point, but since the consumer's response is to press the pay button, he concludes the deal by accepting that offer.
Oh yes, to that extent I don't dispute the point, but the point is not that. The point is that this is an offer based on what the consumer has told Amazon that it wants to have supplied to it.
You say it's pull rather than push.
If you like that language, then it is.
Well, is that a convenient... Sorry.
I beg your pardon.
No, on you go.
Would you please have a think over the adjournment?
Yes.
Whether or not the fact the consumer has supplied some of this information makes a difference,
yes.
and why?
Yes.
Because as I understand it, it is going to be said it doesn't matter. This is a website that molds itself to the developing consumer experience, and it does so in relation to a consumer in the UK before that consumer has bought.
I'll address that point right at the outset, and then go into Blomqvist, which I think I can deal with actually fairly rapidly on the authorities, but I think we're making good time.
Well, you have an hour.
Thank you.
Thank you very much.